Mr. Patton, it's my understanding that you have declared bankruptcy, that some notice has been given, is that correct?
That's correct, Your Honor.
And that basic of your bankruptcy, you've included the real property that I made a ruling on in this case?
Correct, Your Honor.
Based on the bankruptcy laws, and I'm foreclosed from doing anything regarding the real property that's included in your bankruptcy action.
Your Honor has already ruled that that real property is Ms. Patton's.
Agree.
And he is holding a necessary insurance check that Your Honor has already said was awarded to her. This divorce has been completed for some time. Real property was awarded sometime. He's tried to backdoor it by filing a lien in the Register of Deeds office. This real property is fraudulently being placed into the bankruptcy court, and it should not be.
That's for the bankruptcy court. I agree with you. I agree with everything you've said. He has no basis to include this real property in the bankruptcy action. But a bankruptcy court is the sole judge, the sole area that allows for the for the determination of whether the asset that is alleged to do that. So Mr. Patton is treading in very thin ice with the bankruptcy court, because likely the bankruptcy court is going to find, as I have ruled, that he doesn't own an interest in that property. And as a result of that, he has attempted to defraud the bankruptcy court, in my opinion. And I think that the bankruptcy court will need to have an opportunity to determine that, because there's an automatic stay on any proceeding involving property that's alleged to have been included in a bankruptcy action until that bankruptcy court does that. But it doesn't stay this court from finding Mr. Patton in contempt of this court for failing to abide by this court's orders. You have not filed a motion for contempt, but I expect that's what you will do next.
That is what I will do next. We found out this notice was shoved into the door at my office in the middle of the night last night. So we've just found out about it this morning.
The notice of what?
The notice of bankruptcy. So that being said, I did want the court to know about the lien. He is still holding that check hostage. And he has filed some motion to have me disqualified as counsel because his girlfriend has some sort of relationship with Hidden Valley Properties, which our office represents, which is...
Let's hear that motion first.
Okay.
I'll allow him to argue that motion. You filed a motion to disqualify Reynolds, Potter, and Reagan in Vandervoort. You drafted this personally, did you, Mr. Patton?
Yes, I did, Your Honor.
Okay.
So at this time, Your Honor, I am preserving my motion to disqualify under Tennessee Supreme Court Rule 8, RPC 1.7, 1.9, 1.10, based on overlapping representation and confidential information concerns.
All right, I'm here. Anything you want to say?
I mean, I would like to preserve that for a future.
Reserve what?
The motion to just...
Now, we're going to go forward with the motion for disqualification today. So you can argue it, and I'll rule on it. Tell me why you think that this relationship that you set forth with Mr. Vandervoort, being the attorney of record for a realist from some sort of Hidden Valley Lakes or whatever.
Okay. Your Honor, regarding my motion to disqualify, there's a severe conflict of interest that breaches attorney-client confidentiality. Ms. Duke's firm represents Hidden Valley Lakes and its president. I volunteered there, and highly sensitive and private details regarding my active divorce were directly shared by this firm, or with this firm, by the president and Mr. Vandervoort. Opposing counsel has access to confidential information that can be obtained through that representation, and that creates prejudice against me with regard to the divorce matters that completely undermine the integrity of these proceedings.
All right, I've considered your motion to disqualify, and I've reviewed your basis for that, and I find that there is no basis for disqualification of Reynolds, Potter, and Reagan, that the basis that you have set forth would have no effect upon this proceeding, nor would it have anything to do with Ms. Duke's representation of Mrs. Patton. Was there any other motion that needs to be dealt with today? Ms. Duke, I want you to draft an order that this court finds, as I have previously found, that this court has previously ordered Mr. Patton to execute the deed to this property as was ordered originally in the divorce decree, that he has been. The notice of lingua pendis. So that would be a situation where this court would have to deal with that, but I think the bankruptcy court's going to have to deal with that. But I will stand by the order that the court has made regarding the check that was from the insurance company, because I believe that was part of my earlier ruling, that he has 5 days to execute that check. And if he fails to do so, I will hold him in contempt. Mr. Patton, I think you're playing games with the legal system. I think you are attempting to try to divert or to avoid this court's rulings previously. I don't think you have any basis to include that real property in the bankruptcy action that you filed. You are getting some bad advice, and I'm telling you right now that that bad advice from whoever it's coming from, whether it's your girlfriend or some other person, whoever's giving you advice on how you can subvert and get around this court's rulings regarding this case is giving you bad advice. It's going to likely end up in you being incarcerated in jail. I don't want to put you in jail. I want you to comply with the court's orders. But I'm not going to tolerate you playing games. And I don't think the bankruptcy court's going to do that either. And so you might get prepared, because I think the bankruptcy court, when Ms. Patton hires a lawyer and they proceed in the bankruptcy court, they're going to take a dim view of you attempting to use that process. Anyway, that's the order of the court. You may step aside. You may.
So, Your Honor, I had 2 other things that I'd like to discuss if possible.
What are those?
So I would like to be on the record. I'd like to preserve that the deed was recorded before the written order was entered under Tennessee Rule of Procedure 58. A judgment is effective only when written and entered. And third, the deed acknowledgement is defective because I was never personally before a notary. And then, like I said, I asked that the property issues be continued. As far as the check, I have no knowledge of where that check is or where it's supposed to be. Ms. Duke told the court that it was at her office, and I agreed to go sign that check at the office. She later told me that it had been mailed to somebody or somewhere. And at that point in time, I have no knowledge or receipt of this check, Your Honor. So it's not a matter of trying to get around not signing it or avoiding it or anything like that. I have no knowledge of where this check is, and I've not been requested by Ms. Duke to come to her office and sign for this check.
Judge, we have confirmation and tracking that it was dropped off at Mr. Patton's home. And I can't control where the insurance company sends a check. I represented to the court that as they had told us, they were going to send it to my office. They did not. We've got tracking to show that it was sent to his house. He knows he has it, and he's refusing to provide.
Once again, Your Honor, I do not have the check. Never received it. If it was mailed to the house, it's not at the house. So,
Ms. Duke, this court will order the insurance company to issue that check in your client's name only and to issue it directly to your office. And by order of this court, I'm directing the insurance company to issue the check solely to Mrs. Patton, and because she is the true owner of the property, and it's to be issued and mailed to your office, sua sponte. Secondly, your request regarding, or your objection regarding the deed execution is overruled and denied.
Understood, Your Honor.
And I will point out, the original order trumps everything.
This court ordered it from the bench. And it's just like any other order, this court, if it's not in, even though it may not have been a written order at that point, you were ordered to do certain things and you did them. So it doesn't matter if you signed a deed because I ordered you to do so, then later saying, well, that order hadn't been, the written order hadn't been entered, is an attempt to, again, subvert and get around what this court says. Why would you object to the order being, why do you even object? Tell me why that is.
Because I've filed a motion 60.02 to contest this whole process, Your Honor. So it's been under contest since I filed my motion 60.02. And then Your Honor ordered me to sign a quitclaim deed over on the 10th, or excuse me, the 15th.
I'm overruling your objection to the deed because of the fact that this court is of the opinion that you did so in compliance with the court's order. Your Rule 60 motion will have to be heard after the bankruptcy court deals with you.
Well, and it was in compliance with the final decree, so it even goes back that far.
There is nothing in the decree that states that I am to sign a quitclaim deed, Your Honor, and give up my rights to a $150,000 debt. It's attached to a $150,000 debt.
All right. I've made my rulings.
Understood.
Thank you, Judge. I'll submit an order.
The courtroom fell silent when one man claimed bankruptcy to stop a property dispute, but the judge wasn't convinced. After a divorce, the court had already ruled that the home belonged to Mrs. Patton. Yet, instead of transferring the property, Mr. Patton listed it in his bankruptcy case, effectively freezing any action involving the house. His attorney argued that the bankruptcy filing was nothing more than a tactic to avoid following the divorce order. The judge agreed. He warned that while bankruptcy law temporarily blocked action on the property, it did not excuse ignoring the court's previous orders. Then came another issue. An insurance check that had been awarded to Mrs. Patton had still not been signed over. Mr. Patton claimed he had never received it, but the judge wasn't persuaded. Instead, he ordered the insurance company to cancel the old check and issue a new one directly to Mrs. Patton. Finally, the judge delivered a blunt warning. He told Mr. Patton he appeared to be playing games with the legal system and trying to use bankruptcy to escape the court's rulings. If he continued, the judge warned, jail could be next. The hearing ended without handcuffs, but with a clear message from the bench. Court orders aren't suggestions, and bankruptcy isn't a shortcut around them. VidIQ.